that's it. Joe Perini, MG Law. I know so many of you in the room. Thank you for coming. I hope I don't bore you. For those that I don't know, it's good to meet you, and I hope to see you at the closing table soon. MG Law, gosh, been around for 25 plus years. Currently over in the near West End, so a little announcement. As of February 1, we're going to be your neighbors. We're going to be over on Cox Road, so looking forward to that. We cover a pretty broad base of practice areas. I manage our residential transactional team, so I have the privilege to work with a lot of the builders that you all know and love, the RCI Builders and Liberty Homes and a few others as well. I've got a great staff of ladies that are probably your main contacts when you work with us. And then if something goes sideways, I'm here, and then my associate Paul is there as well. But I will say this, when you're talking about topics like we've got today, it's always going to be specific, fact-driven. What about this? Does this variation change the answer? This is meant to be a guideline and to give you some general knowledge and some instruction. But the point is, if you've got a question, go to me or your preferred attorney and get the right answer. But I just want to give everybody kind of a baseline of knowledge of some specific things just to have there. That said, I want to keep this as informal as I can. If you've got questions, feel free to just ask while we're on topic. I'll try to leave a little time at the end for Q&A, but happy to do that throughout the course of the talk as well. Okay, so that said, powers of attorney. All right, what I wrote here as you're not dead, but what happens if I'm hurt, right? So a couple things, and all of this is not necessarily geared towards the nerdy lawyers, but what's practical and important for you all as realtors doing a transaction with these situations. So a couple things to keep in mind. Obviously, it needs to be drafted and signed. A power of attorney needs to be drafted and signed when the person's doing well. If they already are incapacitated, and then you're like, oh, well, we thought we had a power of attorney, but we don't, or it doesn't say the right thing, or it doesn't appoint the right person. Can we do a new one now? No, unfortunately not. So this is a situation where you think ahead, right? For you all, if you've got people that are moving out of town, right, one person or the other involved is not going to be able to be at the closing. Deal with that early on. The power of attorney is not a hard document to put in place. It needs to be specific with the authority to buy, sell real estate, sign mortgage documents, etc. Some lenders will even want it to be specific to their particular transaction, reference a particular property address or a particular lender, maybe even specific as a loan amount, although that's not too common. Deal with it early, have those conversations early on. Then when it comes time for closing, we want the original. It is not a legal requirement that the power of attorney be recorded with the deed that the power of attorney is signing or with the loan documents that the power of attorney is signing, but most title companies will require it, and it's a good practice to do so. So make sure you have hands on the original POA. Get that to your settlement attorney at or before closing so you can record it with the documents. A couple other things. POAs, and I've seen this mess stuff up before, you can't use them to convey property to yourself, right? So a son who's POA for his dad then conveys the property to himself, does not work. That son is not the owner of the property. That POA signature on that deed is ineffective by operational law right away. A lot of times it's not with the malintent, right? Not with the bad intent of I'm trying to get over on somebody. Maybe they feel like it's needed for whatever circumstances they're in, or if it's what that person intended or wanted, it still doesn't work, right? So if you ever see that situation, it does not work, right? You've got to have a signature by POA conveyed to somebody else. And then if you get in a situation where somebody who has a power of attorney now has a problem, they can't grant a subsequent POA. In other words, a POA for dad, maybe son's POA for dad, now son has an issue, let me grant my wife, daughter-in-law POA. Doesn't work, right? Again, I'm trying to speak from questions I've had and experiences I've had, different things that come up. Okay, trusts, not dead, but what happens if, right? And again, practice points for you all. First of all, property property is held by the trustee of the trust, not the trust itself. So why does that matter? When you all are calling saying, hey, how do I get this listing agreement drafted? Who signs it? How do they sign it, right? It's going to be signed as Ben Rogers as trustee of the Ben Rogers Revocable Trust. It's not signed the Ben Rogers Revocable Trust, right? Do you get that distinction, right? Property is held by him as trustee for the trust. Documents have to be signed that way, right? Whether it's the listing agreement, the contract for sale, ultimately the deed, and the other title documents that I'm getting done. Next, that trust needs to specifically give the authority to deal with real estate matters, right? Somewhere in that trust document, it needs to say power to grant, sell, buy, convey real property, right? If it doesn't, if it's just kind of a general grant, it's not going to work, okay? Here's something that happens quite a bit. The trustee isn't around anymore, right? They refuse to act. They're ill themselves. They passed away. Now what? So you kind of go through an order of operations on what to do. Most trusts, if they are well drafted, have what's in that trust as a successor trustee. It's a backup. It's already been named. You're already in place. All you need to do is have the document signed, probably by that new backup or successor trustee. First person is unable to act for whatever reason, and then the second person can act. You're in good shape. If that's not named, hopefully the trust gives you a mechanism to appoint a new one. And it's usually going to be the people that are benefiting from that trust have the authority to name a new trustee, right? I've seen that quite a bit.
I have a question.
Please.
So if you have a trust and you have a trustee and you also have a will and the trustee passes, whoever is the executor of the will, do they have implied powers to do things with the trust?
Well, so you kind of mixing two things.
Okay.
Who's the owner of that property? If the trust was already deeded that property,
Yes.
you're not worried about the will.
Okay.
You're operating under the terms of that trust,
Okay.
all right? And you're not worried about anything else. The whole purpose in many instances of a trust is to have assets pass outside of probate.
Right. Okay.
It's not an asset of that individual, it's an asset of the trust, so the will doesn't even come into effect.
Okay.
Does that make sense? Did I answer your question?
Yes.
If the property is held by Ben's Revocable Trust,
Yes.
right? Then Ben dies. Ben also has a will. I keep picking on you.
Ben dies
Ben dies.
as an executor of his estate.
You're strong
You
enough.
don't care about the executive. You don't care about Ben's will. You're looking at Ben's trust agreement.
Okay.
Okay? Does that make
And you're
sense?
done.
Okay. Couple of other practical points. If that trust is selling, by the way, right, you're listing agents, you're trying to help people through this transaction smoothly, make sure that those folks, that trustee has a bank account for the trust, because proceeds are going to get paid to the trustee of the trust, not the individual, right? That settlement attorney, MG Law, Harvey Driggs, Shaheen, whoever, is not writing a check to the individual. They're writing a check to that individual as trustee of the such and such trust. And the bank's not going to cash it, right? Otherwise. So tell your sellers trust, get a bank account for that trust. They should anyway, but a little point on that. You don't necessarily have to have a full copy of the trust agreement. Sometimes clients are hesitant to give that up. A trust certificate, which is going to be usually a one-page bullet point. What's this for? Who has the authority? Briefly, who are the trustees? You can rely on that, right? So trust certificate will typically take care of most of what we need. Yes, ma'am.
So the trustee needs a bank account. Does that need to be done before death?
Again, we're not worried
Not
about
just
death
the
in the course of the trust. The trust is going to survive death. Tell me your scenario. What do you think those things?
No, we were sitting here talking about like if we have done all our legal work and we've set up the trust of Jim and I both die, there's this trust.
Yep.
I don't have a bank account in that trust name.
That's okay. The trustee can set that up.
That was the question.
The
I just
trustee can
didn't word
set
it
that up.
right.
Yeah. They can set up that trust, that bank account for the trust at any point. Yep. All right. Related back to our first topic, trustees cannot assign over their fiduciary powers. So the trustee actually has to sign. Don't expect that a trustee can give power of attorney to somebody else. That will not work. Okay? All right. Dead people. That's what y'all are here for. The main question to ask when you're dealing with dead people, I'll just get to it. Did they have a will? Did they not have a will? That is question number one. Okay? If they had a will, we're talking about testing, right? To understand the verbiage here. That just means they had a will. All right, what are we doing with it? Number one, we are getting that original will and recording it with the probate clerk's office for wherever that person lived at the time they died. Okay? We're starting there. Have to start there. That will's getting recorded in that probate clerk's office. If it happens to be the same county where your property is, you're done. You're fine. If it's not, then we have to get a certified and true copy of that recorded will and record it in your next county over, right? So somebody dies, they're down living in Raleigh, North Carolina. That will is getting probated in Raleigh. Then you're getting a copy of that certified and true will from the North Carolina court and recording it up here in Henrico County so you can go list and sell their property in Henrico County. Does that make sense? As far as who inherits under the will, this gets to be a lot of confusion, right? I'll stop using Ben, I'll use myself as an example.
Joe, can you back up for 1 second?
Please.
Back up to the probate when you're going to North Carolina, just an estimated time frame for that process to take place, just so we will be familiar with that. If
the answer is, Eugene, it should be a one-day process once you get the appointment with the probate clerk. There was a time, and this really goes back to pre-COVID, just based on staff shortages, you couldn't get in the Henrico County probate clerk's office without 2 or 3 weeks notice at best. In some places, you can call and get an appointment that week. That really depends on the staffing and workload of that particular county. But once you got that appointment, it should be same day. You can get that will recorded. Does that make sense?
Sure.
Okay. The will, just remember a couple things on that. The verbiage of the will really is going to be important here, right? So my home address, 9100 Redmond Court. If I in my will say, I leave 9100 Redmond Court to my children, Jake, Luke, and Ellie, everything else not otherwise names goes into my residuary, right? And oh, by the way, my brother Mike is my executor, okay? If we're trying to sell 9100 Redmond, you need the signatures of Jake, Luke, and Ellie. As soon as that will gets recorded in Henrico County, it is their property. Now, you might have a title company say, I kind of want the executor's signature also just to cover myself. So they're now going to my brother, the executor, to get his signature also. Not legally required. Usually your settlement attorney will push back and say, come on, that's overkill. The will specifically pass this one property to these 3 people, get the signature of those 3 people, off we go. And for your listing purposes, that property, if that will's already been recorded, it's already owned by those 3 individuals. They're listed as the sellers on the listing agreement. They're signing the contract. They're signing the deed. If instead we're selling a different piece of property that I didn't specifically name in my will, right? Maybe it's a rental property, whatever it might be. Then you're dealing with my executor, okay? That falls in the residuary clause, the catch-all, right? You're not worried about the 3 kids named because of 9100. We're not selling 9100 Redmond Court. We're not worried about my kids. You need the authority of my estate to now sell that property, right? So you're going to get the signature of the executor.
same if the kids are minors as well.
Yes, and here's the complication. If the attorney drafting that will was dumb enough, and I'm going to say it, to grant that property specifically to individuals who are minors, then they really screwed up. Because now, yes, they own it, but no, they don't have legal ability to sign, and you're going to get a court to appoint a conservator or a guardian ad litem who can sign for them. So hopefully you don't find yourself in that situation. Hopefully you're dealing with adult children or adult inheritors. Does that make sense?
Oh, yeah.
Okay. What if they died without a will? That's intestate succession. Typically, that stuff follows pretty common sense rules of family tree. But a couple things I want to say on it. First of all, Virginia Code section, and it's quoted which one, in case you want to try to read that stuff, all lays out who inherits and in what order and in what percentages, right? So that can then help you figure out who are the owners, who needs to sign the listing agreement, the contract, and the deed. But you need to do some digging in with your clients early on to get things set up, because we need to create in the land records the paper chain, right? I died, I did not have a will, right? So now, who can sign on my behalf? There is no executor, right? Because I didn't have a will. A couple things need to happen. First of all, there needs to be, again, an appointment with the probate clerk to record, in this case, a document called a list of heirs. Joe Perini died. He left behind the following heirs. Can you list out my 3 children? Okay. You then need to get a hold of those 3 children. They're signing, right? The issue then comes with what happens if you've got all the different permutations of family trees, whether it's stepchildren or spouses that are not the parents of those deceased children, and stepchildren, and all sorts of different things. All those can spur off into a lot of questions of what if and who signs now. The short answer I will give you is that's a great time to start calling me, and let's go through it. But the basic rule is you need to get a list of heirs recorded, okay? Expect that when you are in that situation, and the conversation you're going to have with your clients is, I need to have some people that are not inheriting, that are maybe friends of the family, that can verify what that list of heirs says. I die, I leave everything to my 3 children, okay? My 3 children then go to sign. That title company will not let that deal go through. Your closing will not happen until 2 other people sign affidavits. It's called a disinterested party affidavit that verifies, yes, Joe died and he had 3 children, period, end of story, okay? Because what if my 2 boys went and they're dealing with my estate and they said, my pain in the ass sister, she never did anything for dad, the hell with it, we're leaving her off the list of heirs. And they just list themselves, right? Or dad didn't want to leave this to the sister anyway, let's leave her off the list of heirs. This interested party affidavit is going to say, yep, Joe only had 2 kids, or no, there was another kid out there, right? So title companies know that people get greedy when death happens and money's on the line. So you're going to need other people that know the family to essentially verify what that list of heirs said. Does that make sense? Okay. Make sure I'm not missing too much stuff on it. The biggest thing I will say here, and where I get a lot of the questions, is when you've got typically in a rural situation, property that's been inherited through multiple generations, and there's not been any documentation of that inheritance of those previous deaths. That's what you're really going to get into a homework situation, because for every person that passed away, you're going to have to come up with a death certificate or an obituary. Then you're going to have to record a list of heirs. Even if it's for 2 lengths back, you might be doing that same process for 2 or 3 generations in a row to document all that. And if you get to the point that you can't identify everybody, or you run out of being able to contact everybody, that's where you're in a situation where you're in trouble. You've then got 2 paths forward, neither one are easy. You can have somebody go to the probate clerk and qualify as the administrator of the estate. That'll at least get you through your transaction. Property will sell with the signature of the administrator. Once there's a court order appointing that person, that administrator then has to go through the same process of figuring out who all the heirs are before they start writing checks, but at least your transaction's closed. That's one path. The other path is you're filing a suit to quiet title. That is going to take conservatively a year to sort through, and probably 10 or 15,000 in legal costs. It's just a pain to deal with, right? So we're trying to avoid getting in that situation, but just be aware of it. All right. I ran through that really quick because I try not to drone on. Ben calls me the professor. I think I talk too much. Prof, for sure. I've got a couple other points I want to give, but I wanted to run through that. Questions on dead people situations.
You had mentioned that if you have a power of attorney and something happens to them, you can't just assign it to the next person. If you are in that situation, is that just kind of, I guess, lack of better terms, like as easy as just creating a completely new power of attorney?
So
or how would you handle that?
The person that owns the property, are they still around, right? And they sign a new power of attorney. If they are, yes, it's as easy as just get a new power of attorney and let's replace the old one. Okay. If they're incapacitated, right? Let's say they've got Alzheimer's, you're in trouble, right? Now you're going to get a court order because if that person who's been named as power of attorney is no longer able to act, they've predeceased, they're not anymore, no longer willing to act, it's ineffective. The person that's already incapacitated can't sign a new power of attorney. You're going to get a court order declaring your guardian ad litem.
Don't most power of attorneys have a backup power of attorney?
Typically, yes. Typically, yes. If well drafted.
What was the question?
Do most power of attorney documents have a backup named in the document? And the answer is yes, if they're drafted well. Yes.
So with listing agreements and contracts, should we ever see that the seller is the estate of?
No.
That's what I thought. And I see it all the time, but I didn't think that was correct.
No. So it should be, right, let's not pick on Ben, let's pick on me. If you're selling my house, I've died, I didn't give it to my kids, it's just passed to my estate, and again, I'm naming my brother as my executor, your listing agreement's going to read Mike Perini, executor of the estate of Joe Perini, as the seller. Does that help? Again, trying to keep this kind of practically oriented. All right, other stuff, not necessarily dead people, but it kind of touches on it. Judgments. Everybody know what a judgment is? Kind of, sort of. I sued, I owed the money, I lost, and now it's a lien on title to the property, right? A couple of things that come up with that, again, when it's related to real estate transactions. First of all, they are good for 20 years, at least up until 2021. That changed as in 2021, Virginia judgments got shortened to a statute of limitations for 10 years, but that only applies to judgments that were entered July of 21 and forward. So if they're before that date, they're still good for 20. So they're around for a long, long time. You got to deal with them. And yes, they have to be cleared before you can sell the property. Cleared meaning you either got a hold of that creditor, he told you how much needs to be paid, and you pay them at the settlement statement, or you're getting them to sign a release. The fact that you cannot find that old creditor, just a really, really old judgment, doesn't get you off the hook. Okay? When does the judgment attach to the property? Well, if you're selling for a couple, for example, and they own that property tenants by the entirety, and let's say just one of them, let's pick on the husband, he didn't pay his Capital One credit card bill, Capital One sued him. That judgment is against him. The property is owned by the two of them as husband and wife. That judgment does not attach. Okay? You don't have to worry about it. All that's going to be done at closing is they're going to have, the settlement company is going to have both husband and wife sign affidavits that they've been continuously married the entire time. That judgment's still out there. It's good on other stuff. It can be used to garnish wages or attach to other property. It doesn't pertain to that property that's owned by husband and wife. Okay? But if instead that property was owned differently, right? Let's say Ben and I go in and buy a rental property together. We don't form an LLC, which we should, but we just own it together, tenants in common. That judgment does attach, even though there are two owners. So the tenancy, how you own the property, matters as to whether or not we have to worry about that judgment or not. Let's go back to my situation with the married couple. Judgment's there against only the husband. They're getting a divorce. She didn't know he had a spending habit, and she's done with it, so they're getting a divorce. Okay? During the time of their separation, judgment goes in place, but they're still just legally separated. Property still owned tenants by the entirety, right? Judgment does not attach. Then the divorce decree gets entered before you go to sell the property. That judgment just came into your wheelhouse. It just became a problem because the minute a divorce decree is entered, tenants by the entirety, owning as husband and wife, automatically stops by operation of law. They own it as tenants in common. That means that judgment attaches to the property. Now, technically, it only attaches as to the one debtor's, in my situation, the husband's interest, presumably half interest in the property. The creditor can only attack that half. Try having that conversation with the people at Capital One. They're going to want their money. They don't care how much his half interest might be worth. It's going to be problematic, right? But just be aware of that. If you're listing in a situation with a divorced couple, you're going to want to be really in communication with them, maybe even their divorce attorney. Where do you stand in the process, and when does this divorce get final, right, as it pertains to this and a few other issues, right? They also better have a property settlement agreement that's deciding where the money goes, because you don't want to get all the way to the closing table and then they disagree over who's getting what check, and then the closing doesn't go through because of that. So watch those situations. All right, bankruptcy causes a tremendous number of problems. So, first of all, when somebody files for bankruptcy, they no longer have the sole legal power to sell their own stuff. They went to the courts and said, please protect me from my creditors. Too much is going on. Court says, fine, the law will give you some protection. You got to go through some steps. But you no longer have sole decision-making authority. So before you're selling that house, you've got to go get in touch with their bankruptcy attorney. He's filing a petition with the bankruptcy court to approve the sale. And with that approval is going to be some orders on from the sale, send a check to the trustee for this amount, right? So you got to make sure that court order is in place. And then from the moment that court order is entered, you're closing no earlier than 15 days after that order was entered. There's a by right 14-day appeal period for the creditors. I know, Kevin, this is dry stuff. You close on day 15, all right? Be careful with the bankruptcy situations. All right, judgment still apply to dead people. Just because you passed away, the judgment doesn't go away. It's still a lien on your assets. Now the assets of your estate, you're still dealing with. No, a death of the debtor doesn't get rid of the judgment. Still has to be dealt with if you're dealing with selling that dead person's house. Okay? Questions on that? Also, when it comes to judgments, also when it comes to dead people, the moment those people become the owners of the property, whether it's an intestate situation, right? You recorded a list of heirs, right? I didn't have a will, I recorded a list of heirs. The judgments against those people, right? The one black sheep of the family that didn't pay his bills, those judgments now attached to that property the moment that list of heirs was recorded. Or if the will specifically said, I bequeath particular properties to these people, and one of those people, one of the people inheriting has judgments, those judgments attach automatically by operation of law. You're back dealing with those things. All right? It does suck. You got to pay your bills is where it all comes down to, right? All right. Couple other things. IRS liens. Whole lot of special rules around IRS liens. The biggest thing I would say is call me. They don't operate under the same rules, whether it's timeline, whether it's what percentage they get to the property, whether it's when they attach. Lots of special rules when it comes to IRS liens. Okay? Utility liens. City of Richmond, somebody didn't cut their grass. That actually matters. Has the same lien situation as unpaid real estate taxes. It gets paid first, right off the top. So you got to pay attention to that. Just these are going to be issues that your sellers come up and say, well, why do I have to deal with this? Just say, listen, if you didn't pay your real estate tax bill, Or if you never cut your grass and the city finally did and they put a lien on your property for $35, it has this effect of unpaid taxes. Foreclosures come into a lot of questions. The biggest thing I will say with foreclosures is timing really matters, right? The timing matters. The time, the date of that deed of trust is going to, for the most part, again, exceptions for IRS liens, it's going to clear out any other creditors, any other liens, any other title defects that were younger than, earlier than the date of that deed of trust that got foreclosed on, right? So I'm selling the property. They had a deed of trust on it from 2020. It was a 2020 deed of trust that got foreclosed on. There's a judgment from 2022, forget about it. It got wiped out. But if there was a judgment from 2018 that was on title of that property before that deed of trust got recorded, first of all, shouldn't have happened. That 2020 closing screwed up and missed that judgment. But that judgment from 2018 that is older than the deed of trust that got foreclosed on, it's still there. It's still there. Bankruptcy situations also, let me jump around a little bit. The bankruptcy situations matter with judgments too. If there's a judgment that was recorded on it as a lien on a piece of property, and then that person, their debts were too much, they filed for bankruptcy, they personally are relieved of that judgment. That creditor is not garnishing wages on them and they're not making phone calls to them anymore, but that judgment is still a lien on their property unless the bankruptcy trustee, right, was smart enough and thorough enough to file what's called a lien avoidance waiver, right? Got rid of it as to the property. Otherwise, that debt that they thought got wiped out in their bankruptcy is still going to get paid when they go sell that piece of property years later after the bankruptcy, right? We're getting into the situation where it's a lot of different factors and scenarios. It's all factor, but this is meant to give you guys some general guidelines on what happens. All right. Last thing I'll say, if you're selling property when somebody has passed away, you're selling it within 1 year, you should prep your sellers for the following. Under Virginia law, creditors of the dead person have a year to come forward. So if you're now selling property that belonged to that dead person and liquidating it through the sale of the property, within that year, there's risk for the title company that they could be responsible. They could be on the hook to their new lender, new buyer to cover a lien that comes up afterwards. So what they will do is one of two things. You can either pay an extra hazard premium, pay extra money to the title insurance company, and they'll take on that risk, or you can park the money until that year comes up. If you're within a couple of weeks, most people park it. If you're 4 or 5 months or more away, people want their cash, they pay $300 more in insurance, and they take their cash and they walk home. Good. All right. I think I left a little time. Just a minute.
Thank you, Joe.
While she's getting that going, I'm Lynn Hancock, and I own a company called Always Best Care Senior Services. Always Best Care is a national franchise that is a full senior solution company that's been in business since 1996. I've owned and operated the office here in Henrico since 2009, so just over 15 years and going on 16. I'm focusing today on what it means when someone can no longer stay in their home. They're not dying yet, but they need help. They need significant help, or they're tired of worrying about the outside, the inside, cooking and cleaning and laundry, and their children are following their kids to all of their sports things and all over the country. They can't keep up either. So it's time to look at a senior community. So I'm going to talk about kind of finding the right fit. I'm going to give you some topics to think about if you encounter a family that's in that situation, because most people say they want to stay at home, right? That's what we hear all the time. But they haven't thought about what it looks like when they can no longer take a bath by themselves, get up and down the stairs, get in and out of bed, fix their meals, drive. Their friends and family are scattered, their friends may be passing away, so they get lonely and things like that. So I'm going to talk about the different types of communities that are out there, the benefits of a community for a senior, some of the considerations to take into account. Going to talk about cost of care. So what is most families' largest asset?
House.
Their home, and most of them have paid them off, and then it's built equity, and you're going to sell that home, but that's what they've saved. That is what they use to pay for this. Because families are like, oh no, how are we going to pay for it? They can use that home, that equity, to pay for that, but they need you to help them sell it so that they can actually do that. And then what are the payment options? I'll talk about some things they can add with the other funds, maybe a veterans benefit that they could get, and that's a significant amount. So we'll talk a little bit about that too. The service that we provide here, it is free to the families. We have national, regional, and local contracts with all of the communities to pay our fees, so that doesn't cost the family anything. And we gather all the information. We decide, kind of like you're helping somebody buy a house. What school district do they want to be in? How much can they afford? What do they need? Do they need a fenced-in backyard? How much land do they need? How many bedrooms? We do the same thing. And we schedule and we go on the tours with them. And we act as their advocate to make sure that they make a good match. So the benefits of a senior community are that they also have levels of care. So they can be independent, they can have assistance, they can have memory care, and then there's nursing care as well. So not always in the same facility, but there are different types. There is always additional care and assistance available as their needs increase. They may move in and all they want is the laundry and the meal prep and housekeeping. But if they start to need assistance with activities of daily living, like bathing and dressing, getting out of bed, they have that there. It has nursing oversight. So there's typically nursing in the building, caregivers, nurses, always 24/7. So they pull a cord, push a pendant, and they get someone that will respond with some nursing oversight. There's 24/7 on-site assistance. Big thing is socialization. There's been lots of studies by the Alzheimer's Association that when people age and they're in their homes, they got all the curtains drawn, it's dark, they're not seeing people, they're not interacting, they're just watching TV. Their socialization helps with that dementia. It staves it off. If you have Alzheimer's, you can't stop it, but it can keep your mind active, and the more active it is, the more it can be pushed off. Activities, and then they have only that one monthly bill to pay, as opposed to someone to do the lawn service and someone to do housekeeping and electricity and water, whatever, all of their bills that they might have. There's 55 plus communities, so these are, if someone calls me looking for this, I would be reaching out to realtors to help them find that. So these are places like, I don't know, I think Hometown has some 55 plus communities, RCI, or don't they?
Yeah.
What are some of the names of those? So,
Currently it's Stacks Trail, they've done Cherry Grove, they've done Bell Creek.
So there's lots of those. So that's where the outside is maintained, but the inside and everything about living inside is that there's some social activities, usually a clubhouse and things like that, but the outside's taken care of, but the inside's on you for the most part. They're independent living apartments, and then there's several different iterations of that. Some just have 2 meals a day, some have 3 meals a day, some you do your own meals, but they have other services. So it can just dependent on what that person wants, what they can afford, and location they want to be in. But there's no real help there. They might have a concierge that they can call. They might have pull cords to get to someone that can call 911 if they need it. Then there's assisted living, includes the room, the meals, activities, utilities. Basic care levels are sometimes included, sometimes not. And then most assisted livings have levels of care. Anybody here done anything with a parent where they had to find an assisted living? And so a couple of you have. So it is, and this can be overwhelming for the adult child too. Just to convince them that they need to do it. That's the biggest hurdle that we have. So, and then there's memory care. So many assisted livings have a memory care section. It's a secure neighborhood, higher levels of care, focused activities to help the individuals. I toured one yesterday, and so sundowning is a thing that happens in the afternoons where people with dementia get very agitated and aggravated, and they just are anxious, and their anxiety level increases. So research is showing that if you start around 2 o'clock in the afternoon doing different activities that lead into this dinner time hour that keeps their mind engaged and not starting to get anxious, that it can help reduce that sundowning. So it's really interesting. I thought it was to do an hour of like an activity where they have like nice music playing and singing and maybe standing up and doing a little dancing. Then they do a quieter time where they just have something that they talk about, maybe reminiscing, and then they actually do some meditation. And she was telling us that they really enjoy just the meditation part, and she'll get them all kind of close their eyes and relax. And then they lead right into the dinner time. So it kind of keeps them from getting agitated. So I thought that was kind of interesting. Then there's continuing care retirement communities. So typically these would be places like Covenant Woods, Mechanicsville, Cedarfield, Lakewood Manor, Westminster, Canterbury. People have to make the decision typically to move into these communities when they are 100% independent. They are looking for people that they think, based on their history and their physical abilities, that they can be independent and mental. It's a mental acuity test you have to take too. Independent for 3 years is what they're looking for. And people get on the list for this all the time. They say, well, I'm not ready. Well, if anything changes while you're not ready, and then all of a sudden you're ready, but now you've been diagnosed with dementia, now you can't be ready. That won't work for you unless you pay a whole lot more money and move maybe directly into their memory care or their assisted living if they have it. Another disadvantage for couples is most couples, not all, some couples have come and said, we want to be in the same community, but 2 rooms, separate rooms on the same hall is fine with us. But most want to stay together. And when you're in a continuing care retirement community, you've given them your $400,000 and you're paying them monthly, and one person needs care, unless you bring care in and can afford to do that right in your apartment, they would have to move into a separate part of the building, which is assisted living, maybe, or memory care, and they would not be able to stay together. And typically, they only have studio-size apartments in their assisted living, so 2 people can't even move in there together, unless you get really close. And then finally is skilled nursing, the long-term care. So we call them SNFs in our industry, SNF. These would be like Westport. Sheltering Arms is an acute rehab center, so they are not long-term care, but Westport, Canterbury, Hanover Health and Rehab, Parham Health and Rehab, places like that. And that is one of the few options for someone that is on Medicaid, because a lot of families will say, oh, we're just going to sell everything we have, put it in trust, leave it to the kids, and we're going to let the state take care of us. Better check out where you can stay if the state's taking care of you, because it's not pretty from my experience. So here's kind of the cost of care. This is accessible to anybody. If you go on your computer and you just Google cost of care survey, there's one from Genworth, there's one from John Hancock, there's one from Mutual of Omaha. But this one is the Genworth Cost of Care Survey. That's who I have my long-term care through. Long-term care insurance can help, is one of the few things that can help pay for home care and assisted living. That's not private funds. but if you look at the monthly costs, we're usually looking at, for a home health aide and our homemaker, it's really weird because home health aide is supposed to be the ones that can help with bathing and dressing, and homemaker is the one that is just a companion, no hands-on care. It actually looks like the homemaker is costing more, which is kind of odd to me, but this is the data and I did not try to play with it. But assisted living at a median of 5,700, and this is specific to Richmond, Virginia. So if someone's in a different part, maybe a family's trying to decide if they're going to move someone from another area to Richmond, which would be less expensive, they can go in and put the different zip codes or different areas and find specific to that area. So just as a tool, if anybody thinks that would be worthwhile. But that monthly cost for home care is 6 hours a day. Well, what if you need somebody there overnight, or 12 hours, or 24 hours? It goes up significantly. Round the clock care at $34 an hour. I don't know, it's running 16 grand a month, maybe. I mean, that's a lot of money. So it's a kind of a break-even analysis sometimes. And that's per person. So if you have a couple, it's usually going to run around 10 grand. All right, so payment options. This is something that everybody thinks and asks me. Well, does Medicare pay for any of this? No, Medicare is health insurance. It's to help you, it's to let you go to the doctor, it's if you need to go to the hospital, it's if you need a surgery, if you need a hip surgery, hip replacement, and the rehab to get better. Once you have plateaued, and you'll hear that term, with your rehab, and they determine, and who they is the scary part. The PT may think you're making progress. Your insurance company, dependent upon the Medicare that you have, may decide, oh, you're done all you can do, and we're not paying anymore. So it's up to the insurance company reading those PT and occupational therapy notes to see what they think. So, and they discharge very quickly. So if someone's in skilled nursing for rehab, and they tell you they're going to give you, oh, we'll give you 2 weeks. I've had people get notified on a Friday that mom or dad was going to be discharged on Monday. So it can be very quick. Private pay and personal funds is the most common form of payment. Long-term care insurance, and it's very policy specific to what it covers. I've seen them that only cover nursing homes, true skilled nursing homes. Some cover assisted living and home care. Some only cover home care. So it just depends upon what the person purchased. And I've gotten very good at reading long-term care insurance policies. So reverse mortgages. Not many people want to do this. It's only good for in-home care because you can't use a reverse mortgage if you're not living in the home. It's not good if you're expecting to sell that and inherit and, that property. And I've seen people use all the equity from their home reverse mortgage and then still need assisted living, and then they don't have any funds to pay for that. So it's an option, but you have to be careful with it. Anybody heard of the VA aid and attendance benefit? So this is the benefit for veterans and spouses of veterans. It can be it can be a widow or a widower. They have to have been in the service 90 days, which is not that long, with 1 day during wartime. It has to be one of the acknowledged war times of the U.S. Okay, and there's some gaps. The biggest gap I see is Vietnam, because we weren't officially at war, but people were in service during that time. It can be anywhere from around $1,400 a month that the spouse or the widow of a veteran can get per month. towards their home care or assisted living. It works easier for assisted living because there aren't as many qualifications.
Does that have to be a widow?
No, it can be the veteran themselves, whether it's a man or a woman. I've had female veterans as well, or the spouse. They don't have to be. They can go together, and then you get then they get the $2,500 if they're both going in. You can't be driving any longer, so the ability to drive, and you need to have assistance with 2 activities of daily living. The most 2 common ones I see when people become a fall risk or there's some worry about that is bathing and dressing. It's called standby and assist. It's making sure someone's there while they're bathing. They might not need somebody to physically get in there and help them bathe or dress, but they need somebody there in case they fall. They don't want them to fall. They want to make sure that they're safe. It is also asset and income based. Your monthly cost has to be $1 over your monthly income, which in assisted living or even if you're getting quite a bit of home care is not that difficult. But you can only have about $180,000 in assets. So there is some planning with trusts that can be done with this to stretch out the funds for that veteran and their spouse or that couple. I'm not the expert in either the VA benefit and definitely not the trust. We'll leave that to Joe and his team. And it's a 3-year look back period. So an example is my dad was a veteran. He passed away. My mom could no longer live by herself. We needed to move her somewhere. And she was an independent first. We made the mistake of selling her home and then establishing the trust. We should have put the home in trust and then sold it. But it still works. It's just, it was not the best way to do it. If the home had been in trust before we sold it, I'm not exactly sure the whole technicalities here, but basically it's now her money is in a trust. She's paid for 4 years independent living. She just moved to assisted living, so she can now qualify for that VA benefit because she spent down to that amount that she's allowed to have. But the rest is in a trust, which she doesn't own. Does that make sense?
The trust is a separate legal entity. As much as it
Yeah.
feels weird, it feels like it's one and the same, it's a separate legal entity. So it's not you owning the asset anymore, now the trust has it.
Right.
And that look back period, you just have to do it long enough that it's not considered to be a fraudulent conveyance to evade creditors.
Right. And so that's, I mean, it's just a planning. It's all in the estate planning, basically, and how you do that. But it is a great benefit. I've also had veterans come to me and they might make $3,000 a month. They don't own their home and they don't have any assets. And if they can get another $2,000, I can find them a place where they can live. Does that make sense? And they can get the care they need. So it can work that way too if they have no assets. And it's done legally. You have to have an attorney to do it. I'm not the specialist in the VA or trust, but it is out there and people use it. And then you can actually utilize life insurance if you have a large life insurance policy. And if it's just enough for burial expenses, it's probably not going to work. But if someone has a $500,000 life insurance policy, you can sometimes use a portion of that you paid into for your long-term care. Medicaid and auxiliary grants. This is the last resort. As we all know, Medicaid is state-specific. Virginia is not a Medicaid-friendly state, especially for seniors. It does not pay for assisted living. A person would have to apply for what's called an auxiliary grant. There are very, very few communities that accept it, and some of them I wouldn't wish on my worst enemy. So that's just, someone called me yesterday and it sounds like they their parents on Medicaid, and I think they'll qualify for the nursing home route, and that will be a step up from having to do assisted living for them, because there'll be more choices, but it's still very difficult to work through Medicaid for either of those things. And that's the other thing. People say, well, I'll go on Medicaid and I'll just live in a nursing home. If you don't need help with 3 activities of daily living or have a diagnosis of dementia that is debilitating, then you would not qualify to live in the nursing home either. Questions on any of that?